Today we are looking at the organisation of political power in the United Kingdom. The political organisation in the United Kingdom of Great Britain and Northern Ireland is structured around a monarchy, and the political system is referred to as a constitutional monarchy. The ceremonial role of the head of state is vested in the monarchy, but real power is divided between the executive, legislative and judicial branches of government. Executive power is exercised nationally on behalf of the Queen by the UK government, headed by the Prime Minister representing all of the United Kingdom. Limited executive power is also found at the level of the devolved governments of Scotland, Wales and Northern Ireland. Legislative power is vested nationally in two chambers, the House of Commons and the House of Lords, and regionally in the Scottish Parliament and the Welsh and Northern Ireland assemblies. Finally, judicial power is also expressed both nationally and regionally. At national level, there is the Supreme Court of the United Kingdom, and the courts at regional level are found in three separate jurisdictions: 1 England and Wales, 2 Scotland, and 3 Northern Ireland. The UK is a multi-party system, and three main parties dominate Parliament at national level, namely the Labour Party on the left, the Conservative Party on the right, and the Liberal Democrats somewhere right of centre. The system of government in the UK is known as the Westminster system of government and has been adopted in various forms by many of the UK's former colonies, such as India, Canada, and Australia. Now, let's take a look at the Constitution in the United Kingdom. It is often said by non-jurists that England has a non-written constitution. Strictly speaking, this statement is, however, perhaps incorrect. The UK Constitution, which is made up of written texts and court decisions, is certainly at least partly recorded in writing. However, it is true to say that the rules making up the UK Constitution have not been codified into one single constitutional document. Indeed, it is this lack of codification that makes the UK Constitution unusual at a time when most other democratic countries have adopted a codified constitution. As there is no single codified constitutional document, the Constitution is said to come from a number of different sources. For example, 1. Fundamental documents. Magna Carta is a fundamental document of UK constitutional law. The importance of the Charter is found in the fact that it forced the then King to accept that sovereign power could not be exercised in a completely arbitrary way and was thus subject to control. Under the heading of fundamental documents also comes the 1689 Bill of Rights, vesting sovereignty in Parliament and setting out the rights that UK citizens enjoy under the system of constitutional monarchy that it created. The second source of constitutional documents is UK Parliament statutes. The laws adopted by the Parliament are referred to as Acts of Parliament, and once they are published, they are known as statute law. The more important statutes are said to have constitutional standing, such as the Act of Settlement in 1701, the Acts of Union in 1707 and 1801, the Parliament Act in 1911 restricting the power of the House of Lords, and the EEC Accession Acts in 1972. Another source of constitutional law is the law created by the judiciary. These laws are referred to as case law or common law. Perhaps the most important common law rule is that of habeas corpus. Under this principle, every prisoner has a right to appear before the courts to have the legality of their imprisonment reviewed. As is often the case with good case law, this rule was later confirmed by the adoption of an Act of Parliament, the Habeas Corpus Act, in 1679. There is also Constitutional Convention, which is also a source of constitutional law. Convention refers to certain political customs or understandings that exist between the different branches of power, as regards the manner in which they coexist. For example, the Queen's approval and signature, the royal assent, is needed before legislation adopted by Parliament can pass into law. Next, we are going to take a look at the different branches of power at national level in the United Kingdom. There are a number of different branches of power in the United Kingdom, the first being the monarchy. The Queen is the head of state and titular head of the executive. The Queen has nominal powers, such as the right to call and dissolve Parliament, which she exercises on the advice of the Prime Minister. Also on the advice of the Prime Minister, the Queen confers public honours such as knighthoods. As we have seen, the Queen must also give her royal assent before proposed legislation can pass into law. She holds weekly meetings with the Prime Minister, at which she expresses her views, if any, on government policy. She is also the titular head of the Church of England, which explains why the monarch must be a member of the Protestant Church. The monarchy plays mainly a consultative role in UK politics, but although primarily a figurehead, the sovereign still retains some influence over the exercise of power. The next branch of government we will look at is the executive. Her Majesty's government, on behalf of the sovereign, exercises executive power at national level. As in the case of the Parliament, executive power is based in Westminster and is headed by the Prime Minister, also referred to as the head of government and the leader of the House of Commons. Appointed by the Queen on the advice of Parliament, the Prime Minister then appoints other ministers who together form the national government of the United Kingdom. Senior ministers meeting together with the Prime Minister are referred to as the Cabinet and together make up the inner government. Now we are going to take a look at the legislature. In the United Kingdom, as sovereignty vests in Parliament, in theory, Parliament may adopt any law it wishes, and once adopted, the constitutionality of that law cannot be reviewed by the courts. This is known as the doctrine of parliamentary sovereignty and limits the UK Supreme Court's power to exercise judicial review as compared with the system in place in other common law democracies such as the United Kingdom. Parliament in the United Kingdom is made up of the Queen and the two Houses of Parliament, the House of Commons and the House of Lords. The House of Commons is made up of publicly elected members of Parliament, referred to as MPs. The House of Lords is made up of two types of member, Lords Temporal and Lords Spiritual. The Lords Temporal are made up of either life peers appointed by the government, who have no hereditary right for their descendants to sit in the House, and 92 hereditary peers enjoying a right of a hereditary seat in the House of Lords. Lords Spiritual are bishops, i.e. senior members of the Church of England, and enjoy an automatic right to sit in the House of Lords. This is open to criticism, as being an official in the Church of England is hardly the most pluralist selection base for a modern democracy made up of many different religions. The final branch of power at national level is the judiciary. Judicial power in the UK is divided between the different jurisdictions of England and Wales, Scotland, and Northern Ireland. Thus, England and Wales share the same courts, whilst a separate court system exists in both Scotland and Northern Ireland. Appeals from each of these jurisdictions are heard before the UK Supreme Court, operating at national level. Judicial power in the United Kingdom is divided into two basic jurisdictions, the civil courts and the criminal courts. Although traditionally powerful, the ability of the courts to make law has been on the wane as more and more legislation is being adopted both by the national and regional parliaments and by the European Union, thereby limiting the scope of the UK courts to make law. We hope you enjoyed this introduction to the political system in the United Kingdom.